Good morning, Mr. Gray. It seems like everybody who's come here or been involved in this process, I tried a case against the last year, practice law.
And I suppose you're going to tell everyone, Your Honor, how I won at district court and you had me reversed at the Supreme Court?
Well, you did beat me really bad in district court, but justice was done. Anyway, you may begin your opening remarks.
Thank you, Your Honor. Thank you, ladies and gentlemen of the Commission. I know you've been put upon greatly this time for interviewing lots of different people, and I appreciate the time you'll give me to talk about the Supreme Court this morning. From looking at other applications, I think that probably the first two questions you want to have answered are, why did I apply, and why do I think I might be a good Supreme Court justice? Well, the first question, I've been very fortunate. I grew up in a family of lawyers and educators. I was allowed to go to good public schools in Rockwell City, Iowa, and Calhoun County, and from there I went on to University of Iowa and Iowa Law School, all taxpayer supported. I was lucky enough to clerk for Judge Lay the first year I finished law school in the Eighth Circuit, and then I was lucky, very lucky, to be able to be a clerk for Louis Schultz, who was the Iowa Supreme Court Justice in Iowa City. And from there I finished another year with my dad and my uncle who practiced law in Calhoun County, and I've been spending the last 26 years at the Heidman firm in Sioux City, where I work with excellent lawyers, excellent staff, and I get to work on interesting cases. I've been given a lot of benefits, and I think just like almost all the applicants and certainly all the members of the Commission, we have a duty to give back, and I feel everyone here feels the same. Well, the question then becomes, why the Iowa Supreme Court, and why now? Well, I believe in the integrity of this court and the integrity of our practice, and I believe that integrity was certainly challenged in November in the campaign leading up to that election and the election results. And as disappointed and as surprising as I was at those results, it was what happened next that made me angry and upset. There were attacks on the remaining judges. There were attacks on this selection process. There were half-truths about those election results that were then portrayed as facts. And I think there was a real fear that those attacks would keep good people from applying to be on this court. And I think that would be damaging to this process. Now, just because I felt that people should apply, it didn't necessarily mean that I should. I wasn't sure that I was qualified. You helped because you have a good selection process, and one of the pieces you have is that application. You know, from that finished application you have before you, you know a little bit about me. But for me to spend the time and spend the weeks it took to fill out that application, I learned a lot more about myself, about why I practice law the way I do, and about maybe what I might be able to contribute if I was on the Supreme Court. Let me start back when we were all clerks, back in 1982 and 1983. I was the sole law clerk for Justice Schultz, just as others here were sole law clerks for other judges. And I had the previous year clerked for Judge Lay in the federal system, so I was on my second year as a clerk, while Justice Schultz was on his second year as a judge. This time, though, it was just Justice Schultz, the Secretary Penny, myself, and we were in the Jefferson Building in the Iowa City. And I'll tell you, that was a wonderful year. We would get assigned approximately 3 cases a month. We would divide the cases up. We would do research. We'd argue about the research. We'd draft. We'd argue about the drafts. We'd circulate those drafts. We'd argue about the circulations. We'd argue about the criticisms of our legal analysis. And in the end, we'd come up with an opinion that we would hopefully be adopted by the rest of the judges. Let me tell you a little bit about Justice Schultz. Justice Schultz was an excellent justice. I don't think anyone would say that he ever held himself out as the most academic justice on the Supreme Court. There were others that served that purpose. But he liked people, and he understood their motivations. And he very much liked judges, and he very much understood their motivations. And he had what I call a practical wisdom. And by that I mean he was able to see through some of the most arcane legal arguments and figure out what was really important. And I learned a lot from him. and if I was a justice, I would like to be a justice like Justice Schultz. When the clerkships were over, I went back to my practice law with my dad and my uncle for a while, and then I went to the Heidman Law Firm where I've been for 26 years. I initially did a general practice, and after about 5 to 10 years, I became a trial lawyer. I have tried lawsuits, mostly jury trials, in Iowa, South Dakota, and Nebraska. Those are the 3 states in which I practice, in both the state courts and in the federal courts there. I've seen scores of different judges, and I would think that I try to adopt the best characteristics I see when I try cases. I know that being a justice is more than simply, though, writing opinions, analyzing legal arguments. Part of the justice's role is to oversee the profession of law, and I have some experience, of course, working with lawyers in smaller towns who refer cases to me. I am, of course, also my dad still practices in Rockville City at 83, and of course runs cases by me and then tells me why I'm wrong. I have served on the Grievance Commission for Woodbury County. I've been an investigator for the Ethics Committee at times when I was a young lawyer, and I do represent health professionals before their boards. Another big part of what we do is the administration. I don't know what I can tell you to show you that I think I'm a good administrator. So let me perhaps answer a question that Justice Wiggins has asked many applicants. What happened in November? I don't know that I have the full explanation, but there are some things I can do, and let me contrast what I saw when I was a clerk to what I think I see now. Certainly, 30 years ago, there were controversial decisions. Certainly, the Supreme Court at the time would make changes that were not accepted by the bar, at least initially, and I particularly think of when we adopted pure comparative fault back in '84. There were fights with the legislature over the judicial budget. Then, as now, I think there's a general distrust outside of Des Moines of any order, decision, rule that comes from Des Moines that changes anything that we do as lawyers or as citizens. And I don't think that will change. It's nothing the Supreme Court's done. It just exists. And finally, at that time, 30 years ago, we still had retention elections, and people voted against judges by not such a large margin. They still did it 30 years ago for reasons as diverse as I just don't want them to get a big head. I couldn't figure it out. I just always do that. So what were the biggest changes between maybe 30 years ago and what happened in the fall? Well, usually if the legislature doesn't like a Supreme Court decision, it takes steps to reverse that decision. And if any of you who know the dram shop laws know, if you read them, or at least did, they specifically said, we changed this law to overrule Clarks versus Minks, the social holds liability case. Probably the biggest change, though, is the speed and number of sources of both information and misinformation. And I will tell you, I was very surprised at how much traction the misinformation about the decisions and about the Supreme Court got leading up to and after this election. So why was that? Well, one is the other side had a very expensive media campaign. And maybe the second is that citizens are less connected to the judges, judicial organizations, and the bar than they used to be. And I don't know why that is, but I have 4 thoughts. One of which is we have to have security systems now. People have to be, the easy access to judges in their chambers is gone, and I don't think we can change that. But perhaps judges can be more available to the public outside of their office hours. And one of the things I like to do is I like to bicycle. I like to go on RAGBRAI. I've done it 23 times, and I like to talk to people on RAGBRAI. I don't know that every justice should do that, but I would certainly be willing to.
I did it once. That was enough.
Another big change is that the chambers of the Supreme Court are no longer in the Capitol building. And that means the clerks and the whole support staff are no longer having day-to-day interaction with members of the legislature or the executive branch. How do you change that? Well, you don't give up this beautiful building, but perhaps you do things like hold oral arguments in different parts of the state. That was done when this building was being built, and I know at least in Sioux City that had a lot of favorable feedback. Maybe, and I don't know if the food's improved, but we'd have to walk over to the Capitol building and eat there once in a while. Since 1982 now, the county clerks are now state employees. And I know there were good reasons, financial ones perhaps, to do that. But it comes at a cost. And the cost is, I think, that the people in the counties have less buy-in to the court system. One way perhaps to talk about that is try to find ways to keep the office open more hours. I know that's going to be difficult. I know the financial strains. And maybe work more with Rule 28E compacts that would allow there to be some exchange between employees of the clerk's office and employees of other county court's office. And of course, one of the other changes is where there used to be 9 justices, there are now just 7. There are fewer bodies to meet. Perhaps those Court of Appeals judges could go and do some more public relations, and we could recruit them to do that. In closing, the last thing I'll say, it's difficult to talk about yourself. Bruce Kempka said he would be willing to come and make my case for me if I could make it for him. But
He didn't make.
lunch. I think I'm a person, I like to listen, and I like to try to resolve conflict. I think I am perceived as a reasonable person, and in fact, one of my badges of honor in deposition, I was accused of being too reasonable. Oh. And if I'm a justice, I intend to analyze legal arguments the way I was taught, and that is 1, does it make sense? 2, is it fair? And 3, is it permissible under the law? And that's the end of my opening statement.
Thank you, Mr. Gray. I want to ask the first question because over the years we had a few brushes with each other. And I was always amazed how you could represent your client and do the best job you can, and you're a wonderful attorney. But yet at the end of the day, we were able to have a drink afterwards. I mean, how does that quality, you know, I think the public thinks attorneys should be at each other's necks and throwing things at people and other things. How does that quality get you to be, you know, how does that quality fit with the role of Supreme Court Justice?
Well, I think you're talking about, Your Honor, that good lawyers make arguments. They don't attack each other or each other's clients. Good lawyers in this court come here to make good arguments. And the Supreme Court, while asking the questions, aren't attacking the people making the arguments. They may attack the argument, but those are completely separate things. And I think that that sort of camaraderie that you and I or other attorneys have after a good argument or after a good trial would certainly continue in this court. I don't think we can go to Hollywood and change the opinion that some people have of lawyers, but I think the way we act and the way we're portrayed, both here under these cameras and as people serve on juries and otherwise, can see that that camaraderie exists.
Thank you. Anything from the left side here? Mr. Holm. He's usually first, and Guy will have a question.
That's sort of how we've worked it out.
Right.
It's really nice to see you today, Mr. Gray, and I wanted to echo some of the comments of Justice Wiggins. I've obviously had an opportunity to work with you on cases. You're a consummate professional. Every attorney that I've ever spoken with that's dealt with you has had the highest opinion of your skills and particularly, as Justice Wiggins pointed out, of your professionalism. You're really a lawyer's lawyer, and I mean that in the most sincere way. I'm interested, because of your just outstanding career as an attorney, how you would view the transition moving from what you've done for the last 26 years, which is be an outstanding advocate, into the role of a neutral and into the role of a judge. How do you view that transition? What thoughts do you have about that?
Mr. Holm, you've hit a good point. It is hard for me to talk about leaving a practice that I like and people I like to practice with, and frankly, a lot of attorneys that I practice on other sides of cases. When I first became a lawyer and a trial judge, I was, the one criticism I often heard was that I was too much of a judge and not enough of an advocate. And over the years, I've had to make that change. I can make that change, to be fair. And certainly, when someone comes to my office with a case, whether it be a plaintiff's case or a defense case, and I go through those 3 questions. I would do the same thing when I would listen to an oral argument. I think I can do that.
Anybody else on this side? Okay, it's your turn, Guy.
Thanks, Justice Wiggins. Sir, Mr. Gray, does feel like a little bit of old home week for me here with the number of the candidates, but I'm interested in your comments, if you could expand on what you learned when you were a law clerk here, when I was as well, some 3 decades ago, that you think really would enhance your ability to serve this court today, some 30 years later.
Okay. Well, one of the things, Mr. Cook, that I can tell you is that one of the things I learned as a clerk is how to argue and with the other clerks. In fact, our mutual friend Bob Wilson and I, even yesterday, are still arguing about the case of State versus Ahart, which I think was decided correctly, and he thinks
He needs to give it a rest.
He needs to lose at least that. But that, I think, I learned as a clerk would be very helpful. Obviously, the skills learned as a researcher and the give and take on trying to find the right or acceptable decision on a case is something I learned as a clerk. I think, too, I sensed from that time that the court didn't grab or didn't try to make every decision it could. It only made the decisions that were brought before him. And I think sometimes the public doesn't understand that the court doesn't sit as a king and decide here is what the law is going to be. It only decides the cases on the facts that are brought before it. And if those facts and that issue of law isn't there, the court can't do anything about it. I think that's a very important point. Does that answer your question?
Yes, thank you.
Anybody on the right side? Mr. Fitzgibbon.
Thank you, Justice Wiggins. Hello, Mr. Gray. I'm torn with your application here today. When I first saw that you were making application for our Supreme Court, I thought, here's John Gray, a lawyer's lawyer, a model of decorum, of intelligence and experience, someone that when I think I need a moral compass, I think of you. And I thought, if John Gray goes to the Supreme Court, who will we as lawyers reference as that kind of person? And then I thought, gee, maybe if we get Gray out of the practice, the rest of us might have some work up in Northwest Iowa. But and on a serious note, when you look at your application, you look at the service, the awards you've received, you're a real person. I think it's important for people watching this entire process to realize that there are people of your stature that are willing to give and serve on our Supreme Court. I want you to tell us just a little bit about some of the non-law things you've done in contribution to the betterment of all of us, the legal aid work, the other things that you've done.
Joe, I sometimes forget what I've done, but because I don't keep track. But you did mention Iowa Legal Aid, and I think that is a very important, extremely important part of this state. The work that's done by the the legal aid lawyers in helping people become productive members of this state is incredible. The satisfaction that you sometimes get as a volunteer lawyer in helping people beyond what to them is such an intractable problem, but to you perhaps doesn't seem all that difficult. You just can't measure that. And I've always encouraged people in our firm and other places to become involved in as a volunteer lawyer. And the work that Dennis and his group do in Iowa Legal Aid is amazing. I've also been involved in lots of things outdoors. I've helped put on RAGBRAI. I've been involved in the Iowa Natural Heritage Foundation. I'm on the board now of that.
It's okay to brag.
Well, I can't. I can brag about stuff. I can brag about beer. I know a lot about that, but I just can't do that.
Any other questions?
Thanks.
I had just a comment real quickly, if I could. Hello, Mr. Gray. I know that a member of my family lives in the town you do, and not only are you a good lawyer, you're a good person. I hear that from her all the time. And you're a member of the American College of Trial Lawyers, and of course, this is gonna sound like everybody's just doing tributes to you here, but I think the citizens members ought to know, that's just the best of the trial lawyers in this country, and that's a real honor. I'm not sure if any of other candidates are in that college or not, but you are, and I wanted to point that out because that's something that, very rare in a trial lawyer, but you did it. And, that comes from trying many cases and trying them well, so that was all I had to say.
Thank you.
Ms. Dixon?
Hello, Mr. Gray, and it's nice to see you, and it's a little odd to see you in a more formal capacity other than our grading bar exams. And
Yeah,
just,
that's right.
again, for the commission, my experience with Mr. Gray has been over, at least for me, the past 12 years, and perhaps you longer, in taking on the arduous process of grading bar exams, which is usually a 2-day commitment, twice a year, just reading and grading essays. And just sort of along that line, it's not a great segue, but I noticed you've got some tremendous writing samples in here too. Even though you are a busy trial lawyer, if you could just speak to the commission a little bit about the fact that I think you've still kind of kept your hands in the reading and writing and the researching.
Yes, I have. As I become an older lawyer, I do less and less of the actual writing that I have done in the past. So that included a part of a brief, or excuse me, part of an opinion I wrote with Justice Schultz back in 1983, and then something I did this fall in a med mal case that had lots of really interesting issues, conflicts of laws, whether or not a stillborn fetus had a cause of action under the Iowa's wrongful death statute. I liked research. I like to get in and dig. I like to try to take the facts and make good arguments with those facts.
Any other questions? Mr. Gray, we appreciate you making the long drive here, and we wish you the best of luck. The commission will be adjourned, and we will try to take up again as close to 1:05 as we can.
Okay. Thank you, Your Honor.
Thank you.
Thank you, Mr. Gray.